Hi, this is Andrew Thompson, your Indiana attorney. Today we're discussing defenses to mortgage foreclosure for homeowners. There are 5 basic defenses to mortgage foreclosure we commonly use, and we employ the acronym SOSAD, S-O-S-A-D, to describe these defenses. The first S is for standing. That's the issue of whether the party that has sued in foreclosure actually has the right to a foreclosure. Is it the real party in interest under the trial rules? The second defense, identified by the letter O, involves the original documents that were used at the closing on a mortgage. With respect to these documents, there are issues involving hearsay and the maintenance of the business records thereafter. The third defense, also identified by the letter S, which stands for what's commonly referred to as securitization, or the selling of the mortgage out from under the promissory note, thereby theoretically destroying the collateral for the promissory note. While this defense sounds great in theory, it's very difficult to utilize in the courtroom. The way the case laws have been interpreted don't work out favorably to the defendant or homeowner in mortgage foreclosure situations on the issue of securitization. Letter A, the fourth defense, stands for accounting. The accounting defense deals with potential errors in calculating the amounts owed. This happens a lot more frequently than you might expect, and it's perhaps the best defense you have as a homeowner to foreclosure. It's not a complete defense, but it works very effectively in negotiations with lenders at times. The letter D, for the fifth and final common defense to mortgage foreclosure, stands for dual tracking. Dual tracking is a phrase that was more or less initiated as part of the treatment of the national mortgage settlement between the 5 largest U.S. banks and the various attorney generals of the states and the Federal Housing Administration. Dual tracking indicates a process where the bank is both trying to foreclose on the homeowner and take the property to sheriff's sale. At the same time, it's holding out its other hand toward a loan modification with the homeowner. The national mortgage settlement determined this process to be unfair, but nonetheless, it's not a true legal defense in itself. The actual legal defense is called promissory estoppel, and it applies in the situation of dual tracking where the bank has induced a homeowner to take action in good faith reliance on the bank's efforts at loan modification and taken steps such as withdrawing money from a retirement account toward accomplishing what the bank chooses, and yet the bank continues forward with the foreclosure. So again, the 5 most common defenses to mortgage foreclosure can be described under the acronym SOSAD, which stands for standing, original documents, securitization, accounting, and dual tracking. There are other defenses to foreclosure, including fraud, unconscionability, and the use of various statutes, often consumer protection statutes under federal law. But these are less common and more difficult to prove. If you're a homeowner facing foreclosure, don't delay until it's too late. Call the Thompson Law Office today at area code 317-564-4976 or find us on the web at www.thompsonlaw-in.com.